Lautenschlager. Great information about the Citizens United case, amicus brief, right? General, and will enlighten us about money in politics. Or not.
How they go together. It's an honor to be with you today. In terms of the recount, if any of you for a day, it's a fascinating process. And if you are somebody who kind of gets involved with elections, better than any, field trip, even the best social. I encourage all of you, if you have a day when you'd be able to do that, to do so. Secondly, and decent human beings ever to serve in our state legislature, my good friend Dave Hansen. And then also I hear there's a yet-to-be-named candidate against Rob Coles, who's in the audience, and I'm yet-to-be-named candidate. Announcements, so we won't do that. I've been asked to talk about money in politics. Day 4 of straight days of depositions in the Capitol reopened to members of the public. So I am going to speak, answer a few questions, and run. I have to be back in Madison for depositions tomorrow at 8. And I still have 2. That's why my husband is driving. If you run into him, oh, there he is. I should give a shout out to him. What I'd like to do, first of all, my parents were school teachers and background on campaign finance cases to start with, because I think that if you understand what the fundamental issues are in the insanity that exists now. We passed federal campaign finance reform, and it was relatively meaningful. There was a senator named Buckley, James Buckley, who many of you probably know of, set up. And he didn't like the limits that were placed on candidate expenditures in the federal law. And essentially, what the campaign, or a case that Buckley, his name versus Vallejo, did in 1976 was to uphold the campaign financing scheme that Congress had passed, but for one important issue, and that was that candidates could give an unlimited amount of their own monies to a campaign, and spending limits were also in some way narrowed and not allowed. So when this happened in Buckley, for the most part, people who were progressives were relatively happy because the federal structure had, in essence, stayed intact, but for the wealthy candidate who may be running for office. But the problem with Buckley, and it was called a per curiam decision, so it was a decision of the court, so it wasn't like there was an author to the opinion, it was like the whole court put it out. What the problem with Buckley, though, was it equated spending of money to influence voters with First Amendment free speech rights. So the ability to spend money in order to speak became kind of the focal point for the conservative efforts to say anybody can speak. And a variety of cases followed, but perhaps the next significant thing came when McCain-Feingold came into being. And the McCain-Feingold bill, as many of you knew, put caps on soft money expenditures by not-for-profit organizations, labor unions, and primarily corporations. And so with the passage of the McCain-Feingold bill, McConnell, also one of our really exciting senators, had a case versus the Federal Elections Commission. And the McConnell case, which came down in 2003, started making cutbacks on the original campaign finance laws, but also started making cutbacks on the McCain-Feingold law. And so it allowed certain prohibitions on certain kinds of funding, but it did say that political parties could speak, and that sort of thing. And what was perhaps most interesting about that case was one of my favorite Supreme Court quotes, and we're not sure if Justice O'Connor or Justice Stevens wrote it, but they said, "Money, like water, will always find an outlet." And while they opposed some of the things that were there, they essentially were saying, you know, you can put all these restrictions on these folks, but they'll still find a way to spend the money, which is perhaps tonight's tragic line of the evening. Anyway, then from there we get to a case that was brought, originated here in Wisconsin, and it was the Federal Elections Commission versus Wisconsin Right to Life. And what was interesting about that case was that the folks who joined with they may have been plaintiffs originally, but anyway, the folks with Wisconsin Right to Life were the Wisconsin Realtors Association, not too much of a surprise, and the Wisconsin Education Association Council, because even as late as 2007, it was still the position of virtually all of the unions that this notion that corporations and unions and nonprofits could all spend this independent money was very important to them. And the whole notion of, if you stand back and look at the big picture, the unions and union plus not-for-profit never equals what corporations are going to put in, basic math equation. And so the unions jealously guarding these rights they had to do these campaigns, thinking they could be more strategically effective, fought against McCain-Feingold and the FEC and tried to allow for corporate spending. And of course, in the McCain-Feingold stuff, the soft money expenditures that were banned were soft money issue ads that were banned within 60 days of a general election and 30 days of a primary election, okay? So that's what we're talking about here. So anyway, FEC versus Right to Life was actually not a bad decision, but then came Citizens United. And Citizens United kind of turned the world upside down. And it did so in an interesting way because, it was a 5-4 decision. And again, tragically, most folks in organized labor and a lot of the not-for-profit groups were on the side of Citizens United during the litigation. And essentially what it said was that it eliminated these soft money provisions for McCain-Feingold, and in doing so opened the door for unfettered corporate union and not-for-profit spending on issue ads just prior to the election. Now the problem with that is that it opened it even further, allowing for candidate advocacy. And the only place where it left any kind of wiggle room in terms of the public at large was that it said that there was a requirement for transparency, so that disclaimer requirements could be put in place so that we as members of the public would need to know who did the ad and who made contributions to that, if those kinds of laws are in place, okay? So with that has come just an array of spending, and even before that there was an array of spending. And the one other case I just want to talk to before we talk more generally is one that was Caperton versus Massey Coal. Now all of you may remember Massey Coal from the mining accident that happened in West Virginia some months back. And where Massey, it appears, didn't follow any of the mining regulations and follow any of the safety things. Well, Massey Coal is owned by a guy named Donald Blankenship, who has a lot of money. And he was trying to buy out a company called Caperton Coal, which was much, much smaller. And in doing that, Massey violated the law yet again. And so Caperton sued him, and Caperton got a $50 million judgment against Massey. And the judgment goes up to the West Virginia Supreme Court. And there are 5 members of the West Virginia Supreme Court. 2 of them recused themselves because they were good friends of Massey. He had put them there. And then there were the other 3, and 2 of them were pro-union, pro-little guy justices, and the 3rd was with Massey. And an election was coming up. So Massey gets this case delayed in the West Virginia Supreme Court until after the election. And he goes after Chief Justice McGraw, who is a pro-labor, pro-little guy, pro-consumer fellow, presuming that he will not rule in his coal company's favor. And he spends $3 million in West Virginia, which for West Virginia is a lot of money.